Judges, deans, faculty, students, ladies and gentlemen, it's a pleasure to stand here before you and to present to this fine audience our speaker. One of the joys, I've so far found everything in the deaning business a joy, but one of the main joys is an opportunity like this. I don't propose for a moment to stand up here and describe at length our speaker's career. Most of you are familiar with it anyway, and secondly, he'd hate me if I did that. But he's been willing to leave Washington, the entertainment capital of the world, to come out here and speak to us, for which we're very, very grateful. I have told our speaker in the car on the way over that we are not yet an internationally known law school, but as Daniel Webster said to the court on which our speaker sits in 1853, there are those of us who love it. You grace our podium. You who have taught law, have edited regulation about the law, who have practiced law, and who has now interpreted the law as both an appellate and a Supreme Court justice. It's a pleasure indeed to present the Supreme Court of the United States Justice, the Honorable Antonin Scalia.
Please proceed. Thank you, Howard. Members of the judiciary, faculty, students of John Marshall Law School, ladies and gentlemen. I'm very happy to be here to come see what Howard has left Washington for. I miss him very much. Chief Judge Markey and I, in the days when I was on the Court of Appeals, sat together on a number of cases on the D.C. circuit. You prefer to be called Chief Judge Markey or Dean Markey? How do you style yourself these days? I don't. Dean is fine. All right. We've gone in opposite directions, Howard and I. He went from the bench to teaching. I went from teaching to the bench. It's one of the strengths of our legal profession in this country, I think, that there is the kind of interchange among the bar, the practicing bar, the academy, and the bench that most of the countries of the world don't have. I think it's a strength of our system. We understand one another a lot better because there are practicing lawyers who become judges, there are teachers who become judges, and the knowledge and the experiences of the different parts of the profession are disseminated throughout the whole by the kind of fluidity that we have here. So I think John Marshall Law School is fortunate indeed to have the experience of Chief Judge Markey, but I don't for a minute believe that I wrote it down when he said it. He has found everything in the deaning business a pleasure, or if he has, he's changed an awful lot since he's come here and has become a fool. It's not that long since I've been in academia. Well, I thought I would say a few words this afternoon about the Constitution. We're in the bicentennial period, and it's appropriate to think about it. It's obviously a matter I think about a lot, and I'm afraid we get somewhat jaded about our Constitution. You've heard it by the time you're in law school. You've heard it praised, through grammar school and high school and college. And after a while, you think, well, gee whiz, it's just a lot of nationalistic propaganda, exaggeration. Yeah, it's okay. It's a good Constitution, but it really is not much better than any other country's Constitution. It just happens to be ours, so we're always heaping praise upon it. That's not true. the Constitution means for this country something that it doesn't mean for any other country in the world. A friend of mine in Washington, former, currently at the faculty at Georgetown, constitutional scholar, Walter Burns, published a book a few years ago called Taking the Constitution Seriously, in which he made the observation that's I find very striking because it had never occurred to me, that there is no other country in the world in which that has a word equivalent to our word un-American. It would mean nothing in French political discourse to call a particular idea un-French, or in German political discourse to call something un-German. Meaningless. What is distinctive about this country is that unlike any other nation in the world, we identify ourselves. We consider ourselves bound together, not by genealogy, because we come from all sorts of different backgrounds, races, religions, creeds. Not by residence, but by belief in certain principles. Well, what makes you American is adherence to those. What makes you un-American is opposition to them. And the most important of those principles are set forth in our Constitution. Now, one difficulty with such a wonderful symbol, as I say, is that after a while you get to take it for granted because you hear it praised so often. Let me tell you a little story about an experience I had when I was in the Justice Department that brought home to me why it is indeed true that our Constitution is special. At that time, I was the head of a division of the department called the Office of Legal Counsel, which provides legal advice to the Attorney General, to the White House, and to the general counsels of the agencies. The equivalent office in the Italian government, which did that function and also the function of our civil division in the Justice Department, was celebrating their anniversary. So they had the celebration in Rome and invited their corresponding officers in other governments. So I went from there, delighted to go to Rome on a boondoggle like that, and Rex Lee, later Solicitor General, who was then head of the Civil Division, came along. So we left the Justice Department. Those of you that know Washington know that the Justice Department is this sort of Art Deco building on Constitution Avenue, built in about the 30s, has a pleasant Art Deco flavor to it, and went over to Rome into the offices of the corresponding agency, which is called the Avvocatura dello Stato, and they are located in a building that is the same rooms, the former headquarters of the Augustinian order, where Martin Luther stayed when he was in Rome. Your mind reels backward when you're an American and you go from Art Deco to Martin Luther. And I think every American has this feeling when he goes abroad for the first time, surely, and even sometimes after that. Gee, they're so old, they're so venerable, they have such history, they have such tradition, and we are so nouveau. But then I got to thinking, the Avvocatura dello Stato was celebrating its 100th anniversary. Big deal. My country was about to celebrate its 200th. This country has been living under this single constitution for more than a century longer than Italy. The name Italy represented anything more than a geographic designation, like you might say Asia. It was not a country. For 100 years of our Constitution. Our Constitution has been in effect, and we've been living under the same document for more than a century longer than Germany was anything more than a geographic designation. That's impressive. France has been through 5 written constitutions and something like 11 different forms of government while we've been working on this one constitution of ours. Now, the wondrous durability of the document is attributable to, I think, a number of utterly irreplicable circumstances. Accidental, if you want to think, or as so many of the founders thought, and as I think, providential. Accidents that will never happen again. When else in history has a government been established not by military conquerors dividing up the spoils, or even by political parties parceling out the power, but quite literally by a 4-month seminar consisting of many of the most erudite and politically sagacious people in the country. The historian Clinton Rossiter described the 55 delegates to the Grand Convention of 1787 as follows. The Republic had 2 men of worldwide fame, and both were there. He's referring, of course, to Washington and Benjamin Franklin. It had perhaps 10 who were well known within the bounds of the old British Empire, and at least 5 of them were there. Johnson, Livingston, Robert Morris, Dickinson, and Rutledge. Gorham, Gerry, Sherman, Ellsworth, Hamilton, Mifflin, Wilson, Madison, Wythe, Williamson, Charles Pinckney, and George Mason had won themselves, as best one could in those days of poor communications, continental reputations. Langdon, Reed, Randolph, Alexander Martin, Jennifer, and C.C. Pinckney were major figures in their states, and almost every other delegate was someone whose standing was unchallenged in his part of the country. That's the end of the quote from Rossiter. As for governmental experience, all but 2 or 3 of the framers had served as public officials of a colony or state. If you read the proceedings, the experience that they had had in different varieties of democratic government was extraordinary. A remarkable 42 of the 55 had served in the Congress of the United States under the Articles of Confederation. And as for education, the faculty will be happy to hear this. In an age when very few, even from the richest families, went to college, the 55 members of the convention included 9 graduates of the College of New Jersey, which is now Princeton, 4 graduates of Yale, 4 from William and Mary, 3 from Harvard, 3 from King's College, which is now Columbia, 2 from the College of Philadelphia, which is now the University of Pennsylvania, and 1 each from Oxford and St. Andrews. And several had studied law at the Inns of Court. 6 of these people held professorships or tutorships. These extraordinary people, the cream of the political cream of the society of the time, did not meet a couple of times to drop a general agenda and then leave it to our staffs to work out the details, which is the way it would happen now. I mean, no, not at all. They met personally, 5 or 6 days a week, and 5 or 6 hours a day, from mid-May to mid-September. Almost an entire baseball season, sort of put it into perspective. And after the plenary sessions, of course, they often filled their evenings with conversations, about the problems that had come up at the taverns where they were staying. Now, just imagine getting individuals of that prominence to devote that kind of time to an enterprise like this today. It will never happen again. Unthinkable. Yale University Press, a couple of years ago, finally published a paperback volume of Farrand's records of the convention. Lawyers are always quoting Farrand. Nobody's ever read the thing. You can buy it in paperback now. It's cheap. It's 3 volumes or so, but it's you ought to read them. Most of the records, of course, consist of James Madison's notes. He took notes every day, and when he got back to his room, he'd elaborate upon them and fill them out. But it's a pretty good record. If you read those proceedings of the convention, you will find that they are full of the spirit of the age of reason. I mean that the belief which seems almost naive to us cynical 20th century moderns, that the application of logic and experience to almost any problem will produce, if not perfection, at least a great improvement. They viewed themselves as being engaged in what James Madison referred to as the new science of government. Trying to figure out what is the best way to put together a government. The records are also full of the spirit of honest, open discussion and persuasion. If you flip through them, you have to be struck by the fact that some of the individuals will express one point of view at the beginning of the convention in May, and then in September you'll see the same person supporting quite the opposite position, because what has happened is over the period he's been persuaded by the discussion and conversation. Mind has been changed. Now that sort of openness to persuasion, of course, is just as essential to the continuation of our republic as it was to its foundation. And so also is the spirit of humility and of generous acceptance of the majority's will, expressed in the famous concluding speech of Benjamin Franklin, when he urged all of the delegates on the last day to come forward and sign the document. Almost all of them did. A couple of Virginians, I'm sorry to say, since I'm a Virginian, were among the reticent refusals. We have Franklin's speech in its original form, since Franklin, who was 81 and in ill health, was unable to stand long enough to deliver it. So he gave it to James Wilson of Pennsylvania to read, and Wilson later gave it to Madison to copy. That speech went in part as follows: Mr. President, I confess there are several parts of this Constitution which I do not approve. But I am not sure I shall never approve them. For having lived long, I have experienced many instances of being obliged by better information or fuller consideration to change opinions, even on important subjects, which I once thought right, but found to be otherwise. It is therefore that the older I grow, the more apt I am to doubt my own judgment and to pay more respect to the judgment of others. Of course, the sly old fox. I mean, he's doing a number on all these other people. You know. Very well done. In these sentiments, sir, I agree to this Constitution with all its faults, if they are such, because I think a general government necessary for us, and there is no form of government but what may be a blessing to the people if well administered, and believe farther that this is likely to be well administered for a course of years. Of course, when he says that, he's looking back over his shoulder at George Washington, the president, who has a lock on the presidency. He knows that. I doubt, too, whether any other convention we can obtain may be able to make a better constitution. For when you assemble a number of men to have the benefit of their joint wisdom, you inevitably assemble with those men all their prejudices, their passions, their errors of opinion, their local interests, and their selfish views. From such an assembly can a perfect production be expected? It therefore astonishes me, sir, to find this system approaching so near to perfection as it does. And I think it will astonish our enemies. Thus, I consent, sir, to this Constitution, because I expect no better, and because I am not sure that it is not the best. The opinions I have had of its errors, I sacrifice to the public good. I have never whispered a syllable of them abroad. Within these walls they were born, and here they shall die. And Franklin kept good to that promise, as did almost all of the members of the convention. In the period of ratification debate that followed, they did not. Nobody thought it had everything that he wanted in it. They all had some disagreements, but they didn't badmouth it. They voted on it, and supported it in all its aspects in the ratification debates. Well, having said a lot about the process of the Grand Convention, let me say just a little bit about its product. That product, the product of those 4 months, did not include the portion of the Constitution that we lawyers are most likely to use in court, and the portion that we happen to be celebrating this particular year, namely the Bill of Rights. That was added to the Constitution, as you know, by the first 10 amendments, adopted in 1791. Although the understanding that something like that would be adopted, proposed by Congress, was virtually a condition of the ratification of several of the states. Nonetheless, it's paradoxical, is it not, that that portion of the Constitution, which was an afterthought, should have come to be the most famous and the most popular part of the document. I mean, if you talk to an American about the Constitution, or if you consult the celebrations, the commemorations that have been held in this bicentenary period, the provisions that are given the praise are certainly not the bicamerality of the legislature, or the separate election of the president, or the presidential veto power, or life tenure for judges, for Pete's sake, or the brief 2-year terms for members of the House, or the 6-year term for members of the Senate, or any of the other expertly crafted provisions that pertain to the structure or the constitution of the government, but rather freedom of speech, freedom of the press, freedom of religion, so forth, provisions of the subsequently adopted Bill of Rights. So completely does that portion of the document attract our affection and devotion. But if the virtue of a constitution is to be judged primarily on the basis of that popular feature, I am sorry to tell you that the American Constitution fares pretty badly. Take, for example, the protections against governmental intrusions upon privacy. The United States Bill of Rights contains no more explicit protection than the following: the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. Well, compare that Fourth Amendment with the much more explicit and extensive guarantees of a prominent modern Constitution, which reads, "Citizens are guaranteed inviolability of the person. No one may be arrested except by a court decision or on the warrant of a procurator. Citizens are guaranteed inviolability of the home. No one may without lawful grounds enter a home against the will of those residing in it. The privacy of citizens and of their correspondence, telephone conversations, and telegraphic communications is protected by law." Or consider freedom of religion. Our First Amendment says nothing more than the following: as you know, Congress shall pass no law respecting an establishment of religion or prohibiting the free exercise thereof. Compare that with a prominent modern Constitution which says citizens are guaranteed freedom of conscience. That is, the right to profess or not to profess any religion, and to conduct religious worship or atheistic propaganda. Incitement of hostility or hatred on religious grounds is prohibited. Or freedom of speech and assembly, as to which the United States Constitution says only Congress shall make no law abridging the freedom of speech or of the press, or the right of the people peaceably to assemble and to petition the government for a redress of grievances. Compare that paltry guarantee with the modern Constitution I've been describing, which says Citizens are guaranteed freedom of speech, of the press, and of assembly, meetings, street processions, and demonstrations. Citizens have the right to associate in public organizations that promote their political activity and initiative. Persecution for criticism of state bodies and public organizations is prohibited, and persons guilty of such persecution shall be called to account. How wonderful. You will see the point I've been driving at. You have probably gathered it already when I tell you that the modern constitution I have been describing is that of the Union of Soviet Socialist Republics. Now, of course, I would not trade our old constitution for that in a million years. And if I had to pick a country other than my own in which I thought my own rights would be most secure, I might well pick England or Australia, which are two of the few holdouts in the modern rush of all nations to have bills of rights. Every tin horn dictatorship has a bill of rights. It's almost the first thing a dictator does when he takes office now and then nowadays. The reason, of course, that our Bill of Rights is worth something and the Union of Soviet Socialist Republic is not, is that a Bill of Rights only has value if the other part of the Constitution, the part that really constitutes the organs of government, establishes a structure that is likely to preserve against the ineradicable lust for power the liberties that the Bill of Rights expresses. If the people value those liberties, the proper constitutional structure will probably protect them even in the absence of a Bill of Rights. But where that structure does not exist, the mere recitation of the liberties will certainly not preserve them. So, don't get me wrong, while it is entirely appropriate for us Americans in this bicentennial, especially in this very bicentennial year of the Bill of Rights, to celebrate that part of our heritage, we should realize that what it represents is the fruit of our constitutional tree, not the roots. The liberties it expresses are the reasons that the other provisions exist, those structural provisions. But it is those other structural provisions, those humdrum provisions, which in James Madison's words, pit ambition against ambition and make it impossible for any element of government to get unchecked power. It is those humdrum provisions that convert the Bill of Rights from a paper assurance to a living guarantee. It's a lot easier to get a crowd to form behind a banner that reads, "Freedom of speech or death," than behind one that says, "Bicameralism or fight." But in fact, the latter goes much more to the root of the matter. One final thought, all of the provisions of the Constitution, the Bill of Rights, and the structural portions as well, will only endure in practice so long as they endure in the minds and the affections of the people. We have seen, for example, a significant reduction, if not the utter disappearance, of the concept of enumerated and hence limited federal power contained in the original document. It's not that the Commerce Clause changed, but just that the people's concept of what appropriately came within it changed. The alteration in perception was first expressed, as it always is, through the people's elected representatives, who are the first and ultimately the most influential interpreters of the Constitution. The Supreme Court stood athwart that altered understanding of the Commerce Clause during the first quarter of this century. But the Supreme Court ultimately yielded. As for better or worse, it will always yield to the persistent long-term view of the society at large. The court can stand and protect you against the distortion of original constitutional understandings
produced by the temporary excess of one brief era, the era of McCarthyism, if you need an example. The court can save you from that. But in the nature of things, the court cannot stand against and protect you from a departure from our traditions that is deep and sustained, as the new view of the Commerce Clause was. The reason is quite simple. The judges of the court, contrary to the belief of some, especially law school professors, are not dispatched from Mars. They are drawn from the same society that shares that new understanding. So if the understanding persists long enough, if it prevails long enough, for better or worse, it will ultimately be reflected on the Supreme Court and will triumph. I say for better or for worse because these new understandings are not always for the better. They do not always, for example, expand rather than contract individual freedom. Over the long haul, in other words, the court cannot save the society from itself. Because over the long haul, the court is no more than the society itself. The compromises of principle, the misperceptions of liberty that are believed in the homes, learned in the schools, taught in the universities, will ultimately be the body of knowledge and belief that new justices bring with them to the bench. The Constitution will endure, in other words, only to the extent that it endures in your understanding and perception, and especially in the understanding and perception of the teachers in this law school. That is why I used to find it so upsetting when I taught constitutional law to learn how many students in major universities, the best and the brightest, and presumably those the most interested in the law and in the Constitution, had never read, cover to cover, such a basic part of our constitutional tradition as the Federalist Papers. And those of you students out there, I won't ask for a show of hands, who haven't done that, should be ashamed of yourselves, and do it tonight. It's only a little book, for Pete's sake. And that is also why I thought it worth the time to speak to you a bit about the Constitution today. Thank you very much.
We're sorry you can't spend 2 or 3 weeks with us doing exactly that. And if you are from Mars, I hope we get more Martians on the Supreme Court. The justice has consented to take a few questions before he has to run. Want to put up your hands?
Yes, sir. I'm glad I was clear. Right. Or absolutely. And did you think that I had not conceived of that hypothetical when I wrote the opinion? Of course I had. Let me put on the table, because I'm not sure everybody here knows what the Smith case is. It is a case which held that a state law prohibiting the use of hallucinogenic drugs, including among them peyote, did not have to contain an exception for religious use of hallucinogenic drugs. So that members of an organization called the American Native Church, who used peyote in their religious services, were violating a valid state law. We rejected the proposition that what the First Amendment means is that a law of general applicability cannot be applied against an individual who wants to break it for religious reasons unless the state has a compelling interest. I think the decision is correct for the reasons I set forth in the opinion, but let me talk more generally about the fact that you're troubled by the decision. One cannot decide constitutional law on the basis of whether you are troubled or not, or on the basis of whether you think that the right involved is terribly important. The Constitution does not say whatever you care a terrible lot about is in the Constitution. And any society that tries to pour all of its prejudices and desires into the Constitution will destroy the document. It protects some things, and it does not protect other things. It is not a compendium of all that is good and true and beautiful. For Pete's sake, it contained slavery when it was written. It says some very specific things. It protects you against certain invasions of rights that government was most likely to engage in. Infringement upon your speech, upon your religion, and so forth. Other things that are very important to you, it simply doesn't address. Your right to raise your children any way you want. I can think of a lot of important rights. They are simply not addressed. And you can't put them in there by just saying they are terribly important. It's just irrational. The ones that are there, I will enforce to the limit. The ones that are not there have been left by the Constitution to the protection of the states. Now let's look at the First Amendment and what it says about freedom of religion. It says, Congress shall pass no law restricting the free exercise thereof. Now, if you wanted to say any law that Congress passes which restricts religion is valid except in its application to someone who wants to violate it for a religious reason, you would put that in much different terms. That First Amendment is talking about a type of law. Congress shall pass no law. The law shall be invalid. No law restricting the free exercise of religion. This law on peyote was not a law restricting the free exercise of religion. I can conceive of laws that are of that sort, that prevent certain religious practices explicitly, or even that prevent, if you could establish that they prevented peyote simply because they didn't like the American Native Church. You could say that was really directed at religion. But if it's a general law that isn't directed at religion, it simply does not violate the First Amendment. You can't possibly run a society in which every law, every single law, is spitting on the street. I mean, if I have religious practice, I want to spit, then I'm entitled to spit. You couldn't say it's a compelling state interest. You say, well, Scalia, you're not any organized church, but the First Amendment applies to anybody. They don't have to be an organized church. If the American Native Church can use peyote, Timothy Leary can use LSD. He thought it was a religious experience. He did. I mean, and you'd have to allow that. Or am I going to say, well, Timothy Leary is religious, it isn't important enough to Timothy Leary. How do I know it's important to Timothy Leary? So, I mean, if you take the Constitution seriously, you have to enforce what it says and not try to pour into it other things that are simply not there. It is not to denigrate those other things. They may be very important. But the Constitution does not contain all of them. And if you try to make it contain all of them, the reason I say you will destroy it is that once the people have the belief that it isn't textual interpretation that matters, it isn't the ability to be a good lawyer, to study the language, to study the background of it, to study the historical tradition that went with all of that. once the people come to believe that that's not what makes a correct constitutional decision, but rather what makes it correct is, does it express the deeply felt sentiments of the current society? Once the society comes to believe that, the game's over. Because you will have confirmation hearings for justices of the court that will go something like, Judge so-and-so, do you think there is a constitutional right to do whatever it is? You do? Well, I certainly don't. And my constituents don't. And I'm not going to vote for anyone who thinks that's what the Constitution, as though it's a referendum on what the Constitution says. If you have Constitution by referendum, you have no Constitution. The whole purpose of a Constitution is to prevent majoritarian desires from being imposed, not to permit them to be imposed. So, I may agree with you that it would have been a very good thing to make an exception for peyote use. In fact, the federal government has. In fact, most of the Western states have. In fact, in Smith itself, these people weren't being prosecuted for peyote use. In fact, the state of Oregon probably has an informal religious exception for peyote use simply by the exercise of prosecutorial discretion. These people weren't being prosecuted. You know how the case came up? They were fired because they were drug counselors. And they sought unemployment compensation. And the state said, hey, wait a minute, you got fired for using peyote. And they said, no, we have a religious right to use peyote. So, it wasn't a state prosecution. Now, I think you're being upset about Smith is unwarranted. Don't worry. Yes.
Many colleges and universities, employees and local governments are attempting to pass local policies to govern free speech. What type of constitutional difficulties do you think that these policies will encounter with respect to First Amendment?
Gee, I'm sorry you asked that. I find this a very hard area because one must remember, of course, that the First Amendment only applies to state action. And there is no doubt that government can't restrict certain types of speech. But when you're talking about private institutions doing it, it's something else. I mean, you may argue that it's undesirable to restrict it, but it's very hard to argue that it's impossible to argue that it's unconstitutional to do it. Now, as a policy matter, even, I have some problems. I guess I'm not one of those who automatically says, this political correctness stuff is no good. I mean, much of it I don't agree with, I guess, but I think a private institution has a right to say, for example, we are a polite society. This particular college or whatever it is, we are all ladies and gentlemen, and we don't use dirty language. And if you want to use words like that, be gone. Some colleges used to be that way. You used to be gone if you were of that. And I can't say that was a bad thing, to tell you the truth. And it can be the same thing about insulting people by using derogatory terms. I mean, we just say, get out of here. You're just not the kind of person we want to associate with. If you're a private institution, it seems to me you're entitled to do that. Now, you have to be sensible about what rules you make, but don't come to me and ask for First Amendment protection because it's not the government doing it.
One more, I think.
Thank you. Well, I get that question often. I always begin by saying, to begin with, the Senate can do whatever it wants. It is the Senate show, and I'm not going to criticize it. The Senate and I have a deal. They leave me alone, I leave them alone. But seriously, it is their prerogative, and they can ask whatever questions they want. Now, in normal times,
in normal times, they will not be as inquisitive of the particular legal positions of the nominee. But in normal times, the Supreme Court will not have been such a political issue. When it makes itself a political issue, the hearings will become that way. It has made itself a political issue from time to time, principally by being very activist. And there was a time in the early part of this century when we had an activist Supreme Court, and in the other direction. I mean, you can be activist liberally or activist conservatively. It doesn't matter as far as I'm concerned. They're both wrong. But when that happens, the only check in the political process is the confirmation hearing. So one should expect that they will get very politicized. And I think the founders realized that. They realized that anything Congress touches, it's like the Midas touch, it becomes politicized. It's the nature of the beast. There's nothing wrong with that. There's nothing dirty about it. Politics is not a dirty word in a democratic society. So I think the problem is not the hearings. The problem is that the court has seemingly such a center of political attention. We are so much affecting the lives of citizens in a democratic society where normally you'd expect it's the political branches that affect their lives, that the hearing turned that way. I think it's somewhat ironic that the first victim of this new procedure should have been Judge Bork, who doesn't believe in all this activism. But you know, that's the breaks.
Justice Scalia, you have honored us with your presence. You have graced this platform. I thank you so much. I speak for everyone in the room, I'm sure, for your wisdom and your straightforward comments. Thank you so much.